Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast produced by the Antitrust Law section of the American Bar Association. I'm your host, Anant Raut, and today we're going to talk about the antitrust fight roiling the well-kept greens of professional golf. I'm talking about the fight between the PGA and LIV Golf Tours. And joining me today is my co-host, Anora Wang. Hey, Anora.
Hi, Anna.
All right, to set the scene, you have some of the best golfers in the world getting together and deciding that the only way to get their fair share of revenue from professional golf is to organize themselves into a tour. The year is 1968, and the golfers are Arnold Palmer, Jack Nicklaus, and some of the other biggest names of the era. They launched what we now know and call the PGA Tour. Flash cut to 50 years later, history has come full circle, and some of the game's biggest stars have defected to the biggest threat to the PGA's dominance that it has ever faced, the LIV Golf Tour. In August of 2022, 11 pro golfers who were suspended from PGA events after playing in LIV tournaments sued the PGA for using its power to stifle competition and punish defectors. Within weeks, LIV joined the suit as a plaintiff, and then most of the golfers dropped out of the case. Following that, the PGA filed a countersuit against LIV, arguing that LIV and the Saudi Public Investment Fund, which was its primary investor, wrongly interfered in the PGA's business by offering players millions of dollars to break contractual requirements, which included restrictions on their media rights and the ability to play on other tours. That lawsuit is ongoing. What makes this antitrust peach ice cream sandwich even sweeter is the news that the PGA is also reportedly being investigated by the U.S. Department of Justice for possible antitrust violations in its response to LIV. Anora, who are our guests today?
We're in luck today. We have two guests. One of them is Michael McCann, one of the country's foremost sports law experts, who is a professor of law at the University of New Hampshire Franklin Pierce Law School. Professor McCann is a contributing journalist for sports news site Sportico, and he has written extensive analysis of the legal dispute between PGA and LIV. Our second guest is Kail Jethmalani, who is antitrust counsel at the law firm Axinn. Kail represents clients in all areas of antitrust law, including high-stakes litigation, M&A, investigations, and counseling.
Thanks, Anora. Mike and Kail, welcome to the program. All right, so I thought what we'd do is start with some background on the sport of professional golf, and then talk about the emergence of LIV as a competitor to the PGA, before rounding into a discussion of the antitrust issues at the core of this dispute. So, Mike, let's start with you. What is the life of a professional golfer? What makes the LIV Tour so appealing?
Yeah, and thanks for having me. So the LIV Tour is appealing because of money. It offers higher compensation, at least as structured, for doing less. And I think that's really the fundamental appeal of LIV Golf for golfers, is that it pays more, at least when you look at what's guaranteed in terms of pay. The life of a golfer is one where they do well when they win, but they don't do well when they don't. It's not like, for instance, the NBA or Major League Baseball, where players have guaranteed contracts. Golfers get paid to win. Moreover, they have to pay for all sorts of expenses that in a team league wouldn't occur. For instance, they pay for trainers, they pay for their chef, their caddies. There's all sorts of figures, travel.
That surprised me when I heard that. They have to bring all these people with them out of pocket.
Yeah, it's expensive. And a lot of golfers stop playing because it becomes so cost prohibitive that they pivot to other things like becoming the pro at a local golf course. So when LIV is offering, hey, we'll pay you more, that captured the attention. Regardless of all the other aspects of it, that was appealing. So it's a life where the athletes, again, they can do quite well, especially with endorsements, but they really have to win. It's a merit-based sport. Not to say other sports aren't, but in other sports we know that there are guaranteed multi-year contracts that really change the calculus.
Just so that we have a perspective, how much money were we talking about?
I mean, it depends, right? So, I mean, it would depend on the golfer. Some golfers can make millions of dollars. Others make under 100,000. So it really just depends on the success of the golfer. If somebody misses a cut for a tournament, they may get nothing. In fact, not only nothing, they paid to travel there, they paid for their staff. I get that you can deduct expenses and all that, but that's not the same thing as getting money, right? So, LIV is offering guarantees, at least as it's been portrayed. So, it's for money, just strictly based on money, it's appealing.
I mean, that surprised me as well when I was reading about it, that on PGA Tour, you can actually end up in the hole. You can just be, out thousands of dollars after playing a tournament.
Yeah, it's not an easy life. And this is what makes endorsement money so important, because that's providing a more guaranteed source of revenue. But even there, look at the golfers that are getting significant endorsements. It's those that win. A golfer that's ranked 30th, people may not have heard of them outside the golf community. And that golfer may only be able to get endorsement deals that are fairly modest, or maybe they get free equipment and stuff like that. But yeah, it's not the glamorous life that I think it's perceived by all of us, certainly portrayed on TV. It can be a really hard life and financially challenging.
So not only do you have more money at the top of these tournaments, but the last the last place finisher on a LIV tour still is guaranteed money, which previously had not been the case in PGA. So just a completely different economic calculus.
Yep, absolutely. In a guarantee, let's face it, a guarantee is always something that's appealing.
So LIV appears on the scene, and Greg Norman, who a couple decades earlier had tried to create a competing golf league, the World Golf Tour, gets a second crack at it by partnering with Saudi Arabia's Public Investment Fund, which is willing to invest hundreds of millions, if not billions, to get this league off the ground. And immediately, it's controversial. This podcast is about antitrust and consumer protection, but it is hard to talk about this dispute without at least acknowledging and touching upon the controversy with Saudi Arabia's involvement here. Now, this is not the first time that the PIF, the Saudi Arabian Public Investment Fund, has invested in professional sports. They've spent large sums in Formula One racing and soccer's Premier League. But some of the criticism has stemmed from Saudi Arabia's involvement in the murder of journalist Jamal Khashoggi, as well as their involvement in the hijacking of the planes that led to 9/11. Now, one should also be cognizant of the fact that legal disputes, especially in DC, can also involve PR campaigns. And there is some genuine concern here. And there's an alleged allegation of astroturfing, that this is, the fact that there is a Saudi involvement. Some of these protests may be getting ginned up by comms firms as opposed to just it being a totally organic protest. But this raises an interesting and valid question. Why is Saudi Arabia invested in this? How does this make sense as an investment? So one justification I've seen is that the LIV Golf Tour organizes around a team structure where you have their participating golfers broken up into teams of 4. And the idea is that in a world in which the value of sports teams continues to skyrocket, each of these teams could eventually be its own, billion-dollar franchise. I personally am going to call BS on this. It's like trying to make boxing a team sport. I mean, you could get Tyson Fury and put 3 other boxers around him and say that these guys are the hammer fists, but there's nothing about the entity, the hammer fist, that is going to be worth $1 billion in 10 years. So another argument that's been put forward is that this is sports washing. The idea that because Saudi Arabia has public relations issues, it's trying to improve its worldwide image by investing in things like sports to give it a better public image. This may be the case, but I would also point out, why is this in and of itself controversial? I'm not saying it's right. I'm just saying that the Lakers play in Crypto.com Arena, the Miami Heat signed a multi-million-dollar with FTX. They would not be the first entity to do it, but it may explain their involvement. So with that, I want to focus back on the competition issues here at stake. But before we get there, Michael, there was some criticism directed to the players who are involved in LIV, isn't there?
Yeah, the players are portrayed as disloyal. The players are portrayed as breaching their contractual obligation not to compete, that they agreed to essentially a pledge of loyalty to the PGA Tour. And the PGA Tour would say it's more than just loyalty. It's also essential to marketing their broadcasts, that TV networks need to know that certain golfers are going to be playing in tournaments, that it really goes to the economics of these broadcast deals. And when golfers are saying, well, we're no longer part of the PGA Tour, or we're taking the tour off, we're going to go to LIV and then maybe come back, it doesn't work that way, at least as the PGA Tour has portrayed it. So the players are seen, one, as, again, disloyal. And I think, you get hints of sort of anti-America, that why are you going to a league affiliated with a country with whom we've had a complicated relationship? Whereas the PGA Tour, I think, is seen as more USA, more American. So there's that aspect of it. There's the contractual aspect, and there's the economic aspect, which is you need to play for the PGA Tour. You agreed to it, and it's how we make money in our TV deals that pay these golfers money.
This is actually very interesting since we're talking about economic incentives. I think I know very little about golf, just to admit there, but I think the players have strong incentives to stay within the PGA, right? Because not only with the payment that they're getting from the traditional tours, their ranking is very dependent on their participation in the PGA tours, right? And also, I guess, the viewership. Would you explain a little more about that?
Yeah, so Anora, so one is the rankings, that the global golf rankings do not count LIV. So now there are other companies that are coming up with alternative rankings and things like that, but sort of the leading one doesn't count LIV. And as a result, if somebody goes to LIV and doesn't play PGA Tour, the ranking is going to plummet. That's consequential, one, just in terms of prestige. It's also consequential in terms of endorsement deals, where a company that has reached an endorsement deal with the golfer is going to be less inclined to continue it if the golfer's ranking is plummeting. And some companies are, clearly concerned about the optics of a golfer playing in LIV because of concerns that it's a Saudi league rather than an American league. And that, for a company that's trying to sell products to Americans, that could raise a level of concern that they didn't intend when they went into the contract. So you're right; those are all key issues.
Michael, have you been surprised? You touched on this a little bit, but have you been surprised at how either pro PGA or virulently anti-LIV some of the golfers who are remaining with the PGA Tour have been? I mean, it goes beyond just, I want to work for company A versus company B. There's almost like an identity or a history, a sense of history. Like, can you give us a little bit more shading about what's going on there?
Yeah, I think the golf world is pretty insulated just in general, and that the PGA Tour is sort of at the top. And there's this company, this entity, this rival league that is trying to insert itself in a way that's disruptive. And I don't think the PGA Tour really has a history of dealing with these sort of big disruptions. And my guess is that there's sort of a sense of we're at the top, and we can't imagine that there's somebody else that would try to take us from this perch. And I think they view themselves sort of as, the NFL or the NBA, where there's no rival league, right? That they're at the top. It's, literally being number one. And now there's this disruption that's funded by billions of dollars. I mean, this is a credible threat. This isn't some, sort of, sort of new company that's funded in ways that aren't lasting. This LIV could last forever in terms of its financial backing. So I think part of it is this notion that they're at the top, the PGA Tour, and that there's this disruptive presence. And we know golf has this history, right? There's this history of famous golfers and, sort of these traditions. The tournaments have traditions. It goes to the marketing of them in ways that I think are pretty unique and different from other American sports.
So that gets us to how the PGA responded to this threat from LIV Golf, which is the heart of this antitrust case. And I'd like to now turn to Kail. Kail, what have LIV and the players alleged in their antitrust claims?
Sure, thanks, Anant. There's a couple of different claims that the players in LIV have alleged, and I'll take them step by step. The core of the case really is claims for monopolization or monopsonization, which is on the buy side under Sherman Act Section 2. And there's really three claims under Section 2. One is that the PGA has monopolized the market for the services of professional golfers for elite golf events. So that's a claim that relates to the buy side, to players specifically. So the PGA has monopolized purchasing golf player services, which has the effect of depressing compensation. So that's step one, or claim one rather. Claim two is that the PGA has monopolized the market for the promotion of elite golf events. And promotion of golf events is really what the PGA and LIV do. They're promoters of golf events. So that's a claim on the sell side that relates to golf output. And the other side of that, of that transaction are sponsors, consumers, advertisers, and the like. Now, a Section 2 claim for monopolization or monopsonization, and just to keep things simple, I'll just refer to monopolization generally. You need a properly defined relevant market, and then you need some action that is, reflects a willful acquisition or maintenance of monopoly power that's distinguished or different from just growing or developing a better product or competing aggressively in the marketplace. So if you're not an antitrust lawyer, first, welcome to the podcast. You're not a monopolist or a monopsonist. We can't use the market power that comes with being a monopolist to enhance your market position or to disadvantage others. So the elements might seem superficially quite simple. You need to have a market and you need to have some anti-competitive conduct. The underlying analysis is actually really quite complicated because the existence of monopoly power is very sensitive to the contours of the market that you're looking at. And then understanding what conduct could be improper when you have monopoly power, it's sometimes easy. For example, excluding competitors seems pretty suspect. And sometimes it's not so cut and dry. So, and the other thing that adds some complexity to this case, and
I guess, Kail, before we go deeper on the course, I guess, there are two markets at least relevant here, right? One is the market of the players, and the other, I guess, is a market that's, I guess, comprised of us, like, viewers or potential viewers of golf tournaments, right? Can you talk about them a little bit separately and how they are relevant to the antitrust claims?
Yeah, absolutely. So the claims, the alleged monopolization has different impacts in the different markets. So for the players, it means that the players are alleging that by the PGA exercising its monopoly power, they are receiving less compensation. On the other hand, the players in LIV are alleging that by the PGA exercising its monopoly power, consumers are also harmed in the sense that they have less golf output to view, or that sponsors or advertisers may have to pay more money to the PGA to promote their products. Because there is one fewer golf league, LIV in this case, that would be a competitive alternative, right? And if you have multiple leagues, then you have potentially more golf tournaments. And if you have more golf tournaments, that's more opportunities to sponsor and reach the target demographics that sponsors are looking for, the people that watch golf. So, and the interesting thing here is, in a lot of monopolization cases or in a lot of antitrust cases, you have different conduct that goes to different markets. And here it's really the same set of conduct that LIV and the players are alleging that affect both sides, the buy side transaction and the sell side transaction.
That's very helpful. So, and then I think with the litigation, there was some change in terms of who is actually suing, and then the posture changed a little bit. Can you explain a little bit and why that change it might be significant?
Sure. So as Anant mentioned at the top, and Anora, you just flagged, this case was originally brought by a dozen or so players that had, if you will, to adopt the PGA's language, defected to the LIV tournament. And the PGA responded by suspending them, but because they had apparently violated something called the conflicting event rule. And that rule prohibits a player affiliated with the PGA from participating in competing events without an advance waiver. Now, there's some limited exceptions to that rule, but none that apply to LIV as far as I'm aware, or the players at issue. There's also another rule called the media rights rule that is also at issue that, similarly prevents a PGA-affiliated player from appearing in golf media that is organized by a competing organization without prior approval from the PGA's commissioner.
Yeah. I guess opening to the group, do we think LIV have a solid case here?
So it's interesting. It's an interesting case for a variety of reasons. And one thing I'll focus on is when the players originally brought the case, they moved to enjoin their suspensions. And again, if you're not a lawyer at all and you found this podcast, they moved for a temporary restraining order that would pause their suspensions pending, an appeal effectively through the PGA's processes. And at that time, they went through, they presented their TRO to the court, and the court denied it on the basis that the players hadn't shown that they would be irreparably harmed. But on the antitrust claims, the judge made an observation that the players had raised, I'll quote, raised significant antitrust issues that are facially appealing. And that suggests that the players, at least, facially have a strong case. But in the same breath, she gave with one hand, she took away with the other. She also noted that the PGA's preliminary evidence and arguments, quote, potentially exposed fundamental flaws in the plaintiff's claims. And this goes back to a monopolization case. It's ultimately about balancing pro-competitive benefits of the conduct, so in this case, the conflicting events rule, the media rights rule, versus the anti-competitive harm, in this case, potentially lowered player compensation, potentially less golf output. So, does LIV have a strong case? Well, they definitely have a case that is going to have evidence on both sides, and until you see it and have a chance to weigh it yourself, it's really hard to say how it's going to come out.
I mean, it just seems to me, PGA, monopolist in the sport of professional golf, is trying to maintain that monopoly by preventing its players, who are independent contractors, not employees, they're independent contractors, by locking them up through the enforcement of these regulations within their own rules, conflicting events and media rights, and playing elsewhere. I mean, as a layperson, I look at this and say, well, that seems like a facially good antitrust case.
Absolutely, right. And the interesting thing ultimately is the arguments that the PGA are going to provide in response. One thing that they said, for example, is that LIV's contracts with its players, for all the added money that LIV is giving the players, are even more restrictive than the PGA's contracts. And that sort of raises the question: well, what is the rationale for those rules? And if there is a justification, a rational business justification for those rules that have some pro-competitive benefit, and those benefits offset the facially appealing harms, Anant, that you just mentioned, then LIV loses, or the players lose.
Just to jump in on that, I mean, leagues really require exclusivity. This is a tradition in professional sports where leagues don't want their players going to other leagues, essentially, and that it goes to how they market the product and the reliability to broadcasters that these players are going to be appearing in certain games or events. So there is that tradition. And I mean, for the golfers, this is good, right? We have LIV Golf's offering more money, and the PGA Tour has now enhanced its benefits. So this competition, although it's through a litigation in part, I think has been healthy for the sport. It's certainly been a good thing for the players. And it's interesting when we think of the harm to the players. Judge Freeman, as Kail was noting, she did go along with the restraining order because the golfers weren't financially hurt. They were making more money by going over to LIV. And not only that, she said there's not only no tangible harm, there's no irreparable harm, because LIV had calculated how much money they needed to pay these golfers to make up for whatever reputational harm they were suffering. Their economist came up with a figure. She said, how are you showing damages when you're just offering more money to them to compensate for the loss of rankings and such? So, I mean, it's a fascinating case about sports, how sports leagues operate differently than other businesses.
Right.
Right. I mean, I just think that context is pretty unique.
What about harm to consumers? Like, I confess I don't really watch golf tournaments, but for people who are interested, would they be benefiting from having an alternative tournament to watch? How is that all calculated or considered?
I think it could cut either way. You could argue that it's better to have all of the best players in one tournament because that's a more appealing thing to watch. Or you could argue, oh no, it's better to have two leagues that are offering more TV broadcasts to consumers who are golf fans. I don't know if it gets diluted if there are two leagues where there's no great league anymore. You have two very good league, two B pluses, but no A league. I think it could cut either way.
Can I ask you a little bit about that, about this argument that, there's not really a harm to the players here because look at how much compensation they're getting? Because it seems to me that what you're saying is that you have League One, which argument goes has been paying not competitive amounts. League Two comes in, is offering these more competitive wages. League One is doing everything it can to stop League Two from getting off the ground. Yet League Two persists and is pushing forward, and maybe at a loss, is making these payments. So if you freeze this moment in time, yes, these players are getting more than they would have gotten otherwise, but it's because League One has not succeeded in what it's trying to do, which is prevent League Two from succeeding. So is this time slice the wrong way to look at the harm here to the players?
Right. I'll jump in. I mean, it's an interesting point. I think the question is, what is the PGA Tour really doing to actively, prevent LIV from succeeding? LIV has $640 billion behind it. I don't know what the PGA Tour can do to really prevent LIV. I mean, this is not like a startup company, right? LIV is backed by an amount of wealth that no league in the U.S. has. Even the NFL doesn't have this kind of financial backing. So I get what you're saying. I would just say, to the extent money is the remedy, LIV has more money than any other league, as far as I know, in world history. So I don't know. I'll defer to others on that.
I'll flesh out one more point. Sorry to cut you off, Kail, but no. I think I just want to flesh out one more point that Michael raised before, right? Like, it's not a strange thing that leagues have rules regulating certain aspects of how the competition or how the tournaments are run, right? Like, not just in golf, as we have seen in history of antitrust litigation, other sports leagues being investigated or sued, right? So how do we think of that aspect? Perhaps closer to the case at hand, PGA has been investigated for attempted monopolization before, right? Kail, maybe you can give us a little more background on that.
Anora, it's a really interesting point. The FTC investigated the PGA in the 1990s, in the early 1990s. And the same rules at issue in this case, the conflicting events rule and the media rights rule, were the subject of the FTC's investigation back then. And this investigation, I understand, was predicated on the PGA's efforts to stamp out Greg Norman's competing World Golf Tour that Anant mentioned several minutes ago. And the FTC's theory was that these two rules were unfair methods of competition that would hinder the World Golf Tour. Now, I understand that the FTC staff were in favor of litigating this case, but that it was the FTC economists that ultimately opposed staff's decision on the basis that the PGA had grown golf output significantly in the preceding decade or so, and that growth justified the rules. And just as a point of reference, the PGA Tour in 1984 had 72 events, and in 1994 had 125 events. The purse money increased from about $26 million in 1984 to about $107 million in 1994. So you're looking at, a 50% or so increase in the number of events annually, and you're looking at a, 400% increase, I think, in the purse money over that time. And you can see why maybe the economists said, well, these rules aren't stifling output; they seem to be increasing output, and that is the justification for them. One other thing I'll mention that came out of this investigation, and Anant, it goes to a point that you raised earlier. The PGA were also on the offensive when it came to lobbying with respect to this investigation. So this investigation actually came up in 1995 during the Senate confirmation hearings for Robert Pitofsky, the nominee to lead the FTC at the time. So the PGA, maybe this is past its prologue, the PGA does have a history of leveraging the PR or government relations functions to build its case effectively or to defend itself. And in September 1995, the FTC commissioners voted 4-0 to reject the FTC staff's recommendation to take legal action over these rules against the PGA. So Anora, it's we're history rhymes.
That's certainly the case. I think we can go on and on about the history of sports and sports leagues rules being challenged in the antitrust courts. But I guess just to come back to this case a little bit more, why the players drop out of the case? I guess that's a question that I have had at the beginning of the show. Maybe one of you, Kail and Michael, can answer.
Sure, I'm happy to tell you my perspective, and this is a purely legal perspective. One, I have no special knowledge about this. I can only sort of read the tea leaves. But when Phil Mickelson, who was the lead plaintiff in the original case, withdrew, he issued a statement to the effect that he didn't need to be part of the proceedings now that the LIV, the league, had joined the case directly and could protect players' interests. Another player plaintiff, Hudson Swafford, said something similar. Now, that could be because they have buyer's remorse over the merits of the case. That's certainly one interpretation. But I suspect there's a more pragmatic reason. Being subject to discovery as an individual in an antitrust case is it's certainly not my idea of fun. And, when you're subject to discovery, you have all sorts of dirty laundry that comes out and that you would maybe prefer would not come out. Now, if that was the motivating factor for the player plaintiffs to drop out, the court did order discovery from those plaintiffs or former plaintiffs, so they didn't escape it entirely. But they at least are sitting on the sidelines as a third party where the court might be a little more solicitous of their confidentiality concerns.
And just to build on that, I mean, having been involved in litigation with athletes, not to generalize, they don't want to deal with this, right? They're focused on being the best athlete they can be, having lawyers around, and to Kail's point, discovery requests in particular, they're burdensome, they're distracting, they have a finite amount of time that they don't want to spend on this stuff, particularly when, as Kail noted, the LIV had joined. So I think they kind of got the ball rolling, but they don't need to get to the finish line.
And Mike, sticking with you for a moment, you had some very interesting observations in Sportico about why you think this case might go on for a while, even up to the Supreme Court. Can you elaborate on that?
Yeah, one is that both parties have a lot of money. I think that's just it's interesting. Often in litigation, I don't think we see this kind of wealth with both sides of the case. Secondly, I think the PGA Tour really values the exclusivity aspects that we've talked about, that it's considered essential to their ability to be viable in terms of marketing themselves, ensuring that golfers are going to be playing for them. So they have a stake in this. I think LIV believes, as we've talked about, that they have legitimate antitrust claims that are worth playing out. How does this case settle? I mean, they can't carve up the world. That, I think, creates another antitrust problem where others are going to sue. So, I mean, I don't know. It's hard to end this.
Are you saying we cannot offer Saudi Arabia enough money to settle the case? Is that what you're saying?
I don't know. Like, if they carve up competition, I just think that creates a new set of issues that are subject to litigation.
Right. As we look ahead to how this might end, it does raise a question. And Kail, you were going over the history of the FTC's previous investigation here. Has the era of deference to a monopolist or alleged monopolist ended? Has antitrust law and enforcement changed? Like, if the FTC were looking at it now, today, has the thinking changed such that we might see a very different outcome than we did a couple decades ago?
Well, it's certainly a possibility. And Anant, you mentioned at the top, DOJ is looking at this again. Now, query why DOJ is looking at it now when FTC looked at it, a couple of decades ago, but that's a separate issue. But the enforcement environment we're in is so different today than the 1990s or frankly, even, last decade. It would not surprise me if these sorts of rules that impacted labor, and I use that term very loosely here because they're independent contractors, labor is a focus of DOJ right now. And it would not surprise me that rules that prevented labor from, associating with different companies or trying to find the highest value use for their services. It would not surprise me if those sorts of restrictions are more intensely under scrutiny, no matter who's implementing them, whether you're a monopolist or not, or alleged monopolist or not.
I guess one more interesting aspect to watch, not necessarily from antitrust perspective, is that now in this litigation, Saudi Arabia is a party and can be deposed, right? What to watch there?
Well, I mean, I know that if they can be if the fund can be deposed here, the fund invests in all sorts of businesses, American businesses and otherwise. I would imagine that would be attractive to attorneys who are representing plaintiffs suing different businesses in which the fund has invested, because this would suggest that they're subject to discovery and maybe even being joined as a defendant. So, I mean, just on the surface, it seems like I would be worried if I were, I mean, maybe it's overstating it, but at Saudi Arabia, this case could end up being problematic well beyond golf.
I completely agree with that. And I'll just add the additional observation that it's rare for, or at least a purported sovereign, to be subject to discovery like this. So I completely agree with Michael's point that this is potentially going to open the door in a lot of other areas, for the PIF's commercial investments. On the other hand, you're also seeing quite quickly that no one wants to take these depositions in Saudi Arabia, which is where the court ordered them to take place. No one wants to risk the chance that they're going to end up in prison in Saudi Arabia for even being perceived to have criticized an instrumentality of the government. So yes, certainly it presents a deep pocket to go after, but can you actually reasonably go after it in a way that doesn't put the lawyers' health and safety potentially at risk? It sort of raises an interesting, non-antitrust, non-competition overlay that is going to have to, that this case is going to have for the foreseeable future.
Can you imagine the deposition? How many deals have you lost because of associations about your government? I mean, and if they're under oath, you got to figure they've lost deals because of it, right? So for all the controversies we talked about earlier, can they answer that question truthfully under Saudi law? I don't know.
The business of professional golf is becoming almost as much of a spectator sport as golf itself. Fascinating discussion. Thank you, Kail. Thank you, Mike. Now it's time for us to learn a little bit more about our guests on today's show. Mike, one of the of all the interesting things you do, one that I have found quite interesting is that you teach a class about the Deflategate NFL scandal involving Tom Brady in your law school. Can you tell us about that and how that came about?
Yeah, so it's a one sentence class. It just says he didn't do it. No,
New Englander.
That's it. So that class came about obviously during the controversy of 2015. It was the first. So our law school wanted to start occasionally teaching a class at the undergrad level, and I was picked to teach the first class. And the associate dean said, "Hey, why don't you do a course on Deflategate?" And I said, "How do I do a course on Deflategate?" But then it turns out there's all sorts of interesting issues in terms of labor law, in terms of arbitration, in terms of the admissibility of science in attempts to vacate arbitration awards. And where Roger Goodell, the NFL commissioner, is deciding if Tom Brady did it, and then Roger Goodell is also the arbitrator who reviews Roger Goodell, the commissioner's decisions. It's a fascinating case, and that course, when I taught it, I had a professor at MIT named John Leonard. He emailed me. He said, "I'd love to come to present to your students." He said, "I'm a diehard Eagles fan. I hate the Patriots." He's like, "I've run the numbers and it's being railroaded." He goes, "I wish they did it, but they didn't. The NFL science literally doesn't make sense." So he came to do a presentation, and that night the Boston Globe was at the class, and they wrote a story on it, and his science became instrumental in sort of the science defense of Tom Brady. So yeah, that course was a blast. I love teaching it. It's the first night there were 5 TV crews there, including the Boston TV stations, but also Fox Sports. Katie Nolan, who's now a national figure, she was there. It was a blast, but it was also a really interesting class about law and science and arbitration and labor law. So students have learned a lot.
Have you thought about other classes relating to NFL scandals like Mark Sanchez's butt fumble or Dan Orlovsky taking a safety?
Well, how about Tom Brady's divorce, right? I mean, family law class, you could probably generate a class. So, I mean, there are other controversies that come up, but that had just a unique feel because it was New England, it was Tom Brady, it was Bill Belichick, it was Roger Goodell. I did invite the NFL to come to speak, and they didn't accept my invitation, but I got all sorts of guest speakers, including an attorney for the Patriots. So it was a lot of fun.
Well, I was just going to ask, did you do a poll of the students? How many of them, like the percentage-wise, how many of them were Tom Brady fans? And do you have to do a voir dire process?
Good question, Anora. I wouldn't say it was a neutral jury. I think in the class there were something like 84 students, and I believe 79 or 80 were Patriots fans. But there were several people that weren't. But even by the end, they thought it was really a ridiculous set of allegations that defied science. So, but yeah, I mean, it was definitely not a neutral class.
Well, that must be a fun class. I wish I had some choices like that in law school. Now, turning to Kail, I guess for people who are looking into doing what you're doing now, including law students, young professionals like myself, would you have any advice to them?
Sure. I feel I now have to try and match Michael's pithy one-liner for his class. So if I had to teach a class on advice to young professionals or young lawyers, my one-sentence advice would be fake it till you make it. There's an entire body of science about the value of perceived self-confidence and how it helps you develop your abilities. But that also does mean at some point you do have to work on your underlying skills. You can't just be an empty suit forever. And before you think I'm being, pointlessly provocative, I went to the University of Michigan Law School where they did actually have a class for the law students called Faking It. So I feel like I'm not the only one that has come to this conclusion. So that's I wish it could be as entertaining as Professor McCann's class. But
I wonder how that class should be like, the exam would be pass, fail. And then if you pass, meaning you're good at faking it.
I did not take the class, which I now regret, but in any event.
Oh, fascinating.
Well, Professor Michael McCann, Kail Jethmalani, thank you so much. And for all of you listeners who listen to this Sports Talk Radio edition of Our Curious Amalgam, this has been a fascinating discussion, and it's a case that we're going to be seeing unfold over the months and years to come. Thank you both for joining us. Anora, thank you so much for co-hosting this with me.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.